I'm Rachael Griffith. I'm the managing partner of the Griffith Law Office. We're a family law firm in Tyler, Texas. Today we're talking about 4 different types of formal discovery in family law cases. In your contested family law case, your attorney may send out different requests for information or for documents, and you may receive different requests for information. There's 4 common types that we use. The first is a request for production. The second is written interrogatories. The third is a request for disclosure. And the fourth is a request for admissions. What are these? Well, these are formal written requests that will detail out what is being asked of you, whether it's for you to gather documents or give information. A lot of the information asking for legal theories and defenses and objections your attorney will provide, but you will be asked to do quite a bit of homework. For a request for production, you may be asked to gather bank statements, school records, medical records, text message, communication, copies of things, anything you want to use as an exhibit at trial, you need to produce in these requests. Even if you don't plan on using them, if they're asking you for a copy of something that you have access or care control and it applies to the request, you need to provide it. A lot of times I get objections from my clients. Why are they asking for my bank statements from 3 years ago? Well, in Texas law, if it's discoverable, relevant to the suit at hand, you have to produce it. It doesn't mean it's admissible in court. Doesn't mean that it's going to definitely be used in court. But you have to produce what's being requested of you. And your attorney will go over that list of things with you. Now, if it's too voluminous or time-consuming within the realm of reach, then you may provide a release to the other side so that they can go and do the homework, but you've given them the authorization to gather the information. That, in short, is a request for production. It's mainly asking for documents and things, pictures, bank statements, copies of things, and it could go back years and years, especially with divorce cases. If you have a divorce that's 20 years old, they are allowed to ask for documents from 20 years ago. You may not have them anymore, but they're allowed to ask for them, and you have to provide what you have. In kid cases, usually it goes back to the date of the last order or to the birth of the child, whichever is more recent. Then the next discovery avenue that I'll talk about is written interrogatories. These are questions that you answer under oath, and usually it has to do with naming your witnesses that you plan to call at trial, giving their contact information, talking about where you work, your income, your possession and access of your child, whether or not your child acts differently or reacts before or after a visit with the other parent. Types of questions that you may be asked in court that the other side wants to know your answers before you get to court so that they're not surprised. You have to answer these in full. If there's a relevant objection that is a reason why you shouldn't have to answer it, your attorney will assert those in the written response, and then you'll sign your responses under oath. Don't leave anything out. These can be used against you at trial. So if you answer your questions quickly and you just go through the reasons for something, why you want something modified, for example, and you leave out an important detail that you bring up later in court, those answers can be used against you. Hey, why didn't you say that in these responses that are dated 3 months ago? You were under oath then. It wasn't important to you then. You see how it can be used against you. So you want to think through your answers, answer in full. And with those, in most cases, you're limited to 25 questions. So you're not given a list of 100 questions to answer under oath. We're limited in scope and what we can ask in interrogatories. Request for admissions, that's a different beast. You can ask as many of those as possible. A request for admission is a written request for the responding party to admit or deny that something is true or not true. Simple response. You either admit it, you don't give any details or context, or you deny it. And sometimes the answers, you have to admit in part and deny in part. They ask a compound question, and half of it is something you need to admit, and the other half is something you can deny. Those are your only responses to those questions. So mainly those are used for violations of an order. Did you pay your child support of $100 in May of 2025? Admit or deny? You did not. And then you give your answer. Or admit or deny that you have this paramour and you were unfaithful during the marriage. Just straightforward You will know the answer to the question. It won't be something that you have no clue of the response, because it's asking about your specific actions throughout your case. And so those are unlimited. You can ask as many of those as you want. So you may have quite a bit to go through and admit or deny. It's a vehicle that we use in discovery to really put someone under oath, make them stick to an answer, and see what they're going to say when we get to trial about a certain subject. And then the last avenue for discovery is called a request for disclosure. This is something that is mandated under the Texas Rules of Civil Procedure. There's a certain category of things that the other side is allowed to ask of you, what your damages are, what you're going to be asking for at trial, your legal theories and basis for some of your requests. A lot of this section of responses in discovery, your attorney will talk to you and then do for you, because they have the legal brain to do it. But they'll need some input from you. There's another request there for lists of witnesses, contact information, and income is part of it. So it's a little bit of a shorter response, not as much of a headache to go through. So I hope that this provides a little more insight to the discovery process in most family law cases. There can be other things that you can do to get information, like subpoenaing records from third parties, like banks, police departments, medical facilities. You can put someone under a deposition, whether it's a party or a third party like a witness, if you need more information from them than what you can gather under the other avenues that I've explained. You can schedule a time to put them under oath and get a full deposition. It's as if you were at trial, asking them questions and getting responses. But we use these tools to help settlement be more likely, to help trial go smoother, and so that no one is surprised by what the other person's going to say or do, and all cards are on the table. Of course, if you ever have any questions about the discovery process, hire an attorney or ask your attorney for detailed responses. This is something that you shouldn't take lightly. You should respond fully and be truthful and honest in your responses. If you don't respond fully and you don't give everything in your possession, care, control that's asked of you, then the other side can file a motion to compel. And they can ask for sanctions and say, you're abusing the discovery process, you're abusing litigation, and you're not complying with the requests that are asked of you. Hey, judge, I asked them for all of these things. They didn't give them to me. You have a hearing. You tell the court whether or not you gave those things to the other side. And if the court finds that you are not in compliance, you could be held responsible for their attorney's fees for having to compel your responses, and sanctions above and beyond their attorney's fees to punish you for not responding in full. So it's really important that you sit down and look over everything that's been asked of you and make sure you provide everything that's in your care and control within those requests.